I'd like to welcome you all to this webinar as part of the Hawkswell-Kilmington International Construction webinar series on FIDIC 2017 Revisited and Reviewed Almost 10 Years On. And I've subtitled this Only Time Will Tell for reasons that will start to become clear. So welcome. Just in terms of housekeeping, I'm going to try and keep this to just over an hour, maybe an hour and 10 minutes, to allow a little bit of time for questions, so long as I pace it properly. In terms of the structure, there's a number of topics that I'm going to go through, and you'll get to understand why I'm going through these points from my introduction. But here generally is the contents of this webinar. So, on the 5th of December 2017, FIDIC launched the second editions of the Red, Yellow and Silver books at the International Users Conference in London. I wrote about those contracts 8 days later. I then wrote about them again in March in 2018 and published an article in the Construction Law International, the publication of the IBA. And that was after a detailed study and a 4-day workshop that I gave in February. Now, almost 10 years have passed since then, and I thought it'd be a good time to go back and review and revisit 2017. Now, in those two pieces, the Practical Law blog and the Construction Law International article, I made a number of predictions, and some of them were right, some of them were wrong. And one of them, FIDIC has quietly conceded. I'm going to try not to be insufferable about this, and I'm sure it's got nothing to do with me, but we'll touch on it in a moment. This is not a walkthrough of what changed in 2017, partly because it would take days, literally, and partly because I'd expect that most people are familiar with the changes. And also you can get that anywhere. And many of you have lived it. But this is me in many ways marking my own homework in public 10 years on. And whilst I'm using my own work, I don't want to suggest this is all about me. I just think it's very useful to provide a framework to go back and to consider where we are now, almost 10 years on. Now, before we start, it's also worth flagging that FIDIC published a reprint in November 2022. This included amendments that were made, as well as erratas that were previously published in 2018 and 2019. Now, many users are still working from the superseded print, the 2017 editions, and possibly without knowing it. And so probably one of the key takeaways from this webinar is to make sure that you're working off the right version. Now, before I start making any predictions, I wanted to briefly set out the contents of this webinar. Well, I've already set out the contents of the webinar, but to spend a few minutes looking at the background to FIDIC 2017 and on why FIDIC did make any of the changes in the first place. Because most of the commentary that I'm about to give only really lands if you understand what they were trying to achieve. And this is not intended to be a history lesson. We don't have time. But FIDIC 2017 can be traced back in one way, back to 1957 with the first editions of the Red Book, and even before that with the ICE forms of contract. But for now, the place to start is the 1999 forms, which represented a reset by FIDIC and was led by Peter Bowen, who is the principal drafter for those contracts, a single principal drafter. Now, the 1999 forms were drafted before there was drafted for widespread use in non-common law jurisdictions. And this was assisted with the guidance of Chris Seppeler, who was involved with the contracts committee to make that transition. And in particular, we're looking at civil law jurisdictions. The 1999 forms, when they were published, was obviously before Clause 20, the claims clause, had been litigated probably to exhaustion. But what this has happened was by 2017, there was 18 years of accumulated feedback. And also, FIDIC had published the Gold Book, the DBO form in 2008, a revised updated MDB form in 2010, and a FIDIC Red Book subcontract in 2011. And a lot of what might have looked new in 2017 can actually be traced back to these forms. But there was also the fundamental underlying principles that FIDIC adopted for the 2017 editions. And effectively, there were 6 of these. One is they wanted to keep what they maintain as a fair and balanced risk allocation. They very explicitly wanted to enhance the project management tools and mechanisms in the contract. They wanted to increase the clarity and certainty of the wording, to incorporate the most recent developments from the more recent FIDIC contracts, and that's what I've mentioned, the FIDIC Gold Book, the MDB forms, the subcontract, to reflect what they consider was current best practice, and also to reflect user feedback on the 1999 forms. Now, these can be summarized as clarity, certainty, and what I would suggest is dispute avoidance. The aim was to reduce disagreement about what the contract means and when things must happen. And certainly, from when I first picked up the 2017 editions and the earlier review editions that they were, it felt like what they were trying to do was to pick up on all of the potential points that can go wrong or where there are tensions and bottlenecks, and to try and address them very expressly and explicitly in the final text. And it's also worth, in passing, mentioning the 2016 pre-release of the Yellow Book, which was the first version of the 2017 editions that was being amended. Now, when that came out, it took quite a lot of criticism, and FIDIC, to its credit, did actually incorporate and take into account a lot of that criticism in the final text. One other key point to make is that conceptually, I think that the second editions are almost identical to the first editions in terms of risk allocation, with only minor amendments. And so in terms of the results, and again, a lot of people will be very familiar with this, the structure of the general conditions remain very familiar, but every clause has changed. And I went through at the time on a line-by-line review to see that. A few of the other changes are on there. We don't really need to go into those in detail, but there's now 21 clauses. Disputes and claims have been separated. There's been some improvements and developments in terms of definitions. Some different terminology is used, and some of the key changes were the limitation of liability clause moved. Structurally, there was a reordering and renaming of clause 17, and clause 18, 19 order had been changed, and a lot more of the clauses had been broken down into subparagraphs. In terms of some of the common themes, as I said, clarity and certainty, enhanced contract management and dispute avoidance probably captures most of it. In terms of improved project management, they've incorporated express provisions in relation to meetings and advance warning, program requirements and QA requirements, largely reflecting where the market was going. One noticeable theme in many of the changes is that there is greater reciprocity, and this was one of the criticisms that many people raised in relation to the 1999 tweet, as it seemed that unnecessarily one-sided, where it was requiring the contractor to do certain things but not the employer. And this has been incorporated with amendments and also additional clauses. And the changes are largely common to all 3 books. So the Red Book, the employer design book, the Yellow Book, the design build form, and the Silver Book, the EPC contract. So what does this look like? Well, the general conditions generally are over 50% longer. The guidance notes are approximately twice as long. The defined terms are up by about half. For example, in the Yellow Book, it went from 60 to 90. There's many more deeming provisions. And 5 clear time bars, certainly in terms of the claims and disputes provisions, when previously there were 2. In terms of the reception, and again, what I'm doing is trying to look back to 2017 and early 2018, it was split. The initial feedback felt that some welcomed the initial additional certainty, but other questioned whether all the changes were actually necessary, and in particular necessary for all projects. Some contractor bodies, the EIC being the most prominent about them, were also objected vigorously, and again following its criticism and objection and position back in the 1999 contracts, particularly in relation to the Silver Book. There was probably also a universal critique that they're just too long, and this is something that hasn't really been answered. And there are many reasons about the length. Partly, as I said, is because there's the clauses have been broken down and put into subparagraphs. There's additional wording in order to create greater clarity. And in some ways, the second editions read as if guidance notes have been included within the contract. And that's the debate that we were having in the public very early on. But there is a different question underneath, and it's the one that I want to spend a few minutes on, because it will lead into many of the topics that I'm going to be talking about today. Now, this argument runs in 4 steps. And I want to put that out plainly so you can see if you think it breaks down. Now, step 1 is that FIDIC left the substantive risk allocation when compared to 1999 broadly intact. Now, that was deliberate. It was stated, and on any fair reading of the second editions, I think it's true. Some improvements were made to the drafting, picking up on comments and also amendments that were commonly made to the 1999 suite, and some of these will be discussed later. Step 2, at the same time, FIDIC imposed a dense regime of notices, definitions, time periods, deeming provisions, setting out consequences for non-compliance. Step 3, and this is the step that I think matters. That regime, which has created greater certainty, is reciprocal on its face. Clause 20, the claims clause, now applied to both parties equally, to the contractor and the employer, whereas previously there was an asymmetry. And this, I think, is probably a genuine improvement. But it's reciprocal on paper does not necessarily mean it's reciprocal and symmetrical in practice. Because if you ask yourself which party generates most of the claims on the project and which party has the least administrative slack when things don't necessarily go right or things arise, and which party carries the cash flow consequences of every week of delay, in both in terms of progress and decisions, the same answer for all of those is the contractor. So this is a regime that picks up on administrative non-compliance, which bites hardest on the contractor, whatever the drafting says. Now, turning to step 4, this means that the fair and balanced allocation that FIDIC carefully preserved on paper may have been quietly redistributed in practice, not by anybody deciding to move it, but as a product, as a byproduct of how that contract is administered. That's the thesis. Procedure is not neutral, and procedure is itself, or can be, a risk allocation mechanism. So back in December 2017, I said that I wonder whether in practice the second editions may actually have the unintended effect of changing the fair and balanced risk allocation that FIDIC contracts are known for by shifting risk to the contractor. Now, I also said and closed that with only time will tell. Now, 10 years on, has time told? And for this reason, when we're talking about the processes and procedures, I'm going to start with talking about the engineer and claims and disputes, because this is about entitlements and decision making, which is embedded in the employer's role, determinations and claims. So now, my deep dive number 1, the engineer. Now, I've chosen this as the first topic to discuss for a couple of reasons. The role of the engineer is central to a functioning FIDIC contract, apart from, of course, with the Silver Book, where you have the employee's representative, but bear with me on this one. And the second reason is because the changes to the provisions relating to the engineer, particularly in Clause 3, as those introduced in 2017, best illustrates FIDIC's approach generally to those to the changes that were made. In relation to Clause 3, less than 2 pages in the 1999 editions became over 5 pages in 2017. One clause, Clause 3.5 in 1999, and 3.7 now in 2017, went from 2 paragraphs to 3 pages. And I also made several predictions in relation to these changes, which we can pick up now. Now, the first one I wanted to talk about is this question about neutrally and the engineer acting neutrally. Time for a quick history lesson. Now, the engineer as a contract administrator has been a central feature to the FIDIC contracts from the beginning. Its early origin with the first edition of the Red Book, as I mentioned, which came out in 1957, can be traced back to the IC forms, an English form of contract. Now, prior to 1999, there developed an unquestionably Anglo-Saxon concept of the independent, trustworthy, almost venerable engineer, using the words of Christopher Wade, who was a former chairman of the FIDIC Contracts Committee. Now, this was accompanied by a lot of case law and common law jurisdictions as to the duality of the engineer's role. And when I mean duality, I mean, on the one hand, acting directly as agent for the employer, and secondly, as a decision maker, exercising discretion. And that common law, that case law through common law jurisdictions produced what was understood to be an orthodox definition of the role. The engineer's duty when exercising a discretion can be defined variously as acting fairly, impartially, in an unbiased manner, and even in certain circumstances independently. And this is represented or reflected in the drafting of FIDIC contracts. For example, in FIDIC 4, the Red Book in 1987, that codified the engineer's duty when exercising discretion as requiring them to act impartially. Now, however, beyond common law jurisdictions, this concept of impartiality and the duty of the engineer has turned out to be very, very difficult to export. This is particularly the case in civil law jurisdictions where it can come up in direct conflict with governing law, and even in certain common law jurisdictions that do not have a history and experience of this third-party engineer, or even simply where employers cannot or do not understand how the engineer can be neutral. An essential reason for this is the conflict between the engineer being appointed and paid for by the employer and also being required to act impartially as between the employer and contractor. Now, the more that FIDIC has been used internationally, the more problems have actually arisen in practice from this concept. And this led to the express duty of impartiality being intentionally dropped in FIDIC 1999 and replaced instead with an express duty to make a fair determination, i.e. to act fairly. Now, this didn't actually resolve the difficulties in implying this as a concept. And so FIDIC 2017 doubled down. The first thing they do, the first thing that the FIDIC 17 contracts did is to supplement the duty to make a fair determination with a duty to act neutrally. And back in 2018, I noted that the use of this word neutrally, which in itself seemed to be potentially nebulous. And I wondered whether or not it had connotations of impartiality, which was something that the drafters of FIDIC 1999 had intentionally avoided. But it was not only the introduction of this duty to act neutrally that has changed the dynamic in FIDIC 2017. At the same time, they've gone further. They firstly expressly removed the engineer's deeming agency, so it's not being deemed to act for the employer when making determinations, and it's included an express statement that there should be no requirement for the engineer to obtain the employer's consent when making a determination. The effect of this is to seek to unfetter the engineer from a requirement to obtain the employer's approval when making a determination. Now, the rationale for this is quite clear, and the guidance notes and the particular conditions state that along with the word neutrally, this is intended to establish that the engineer treats both parties even-handedly in a fair manner, in a fair-minded and unbiased way. Now that, to me, sounds like impartiality without using it. This seems to be a return to 1987. And you will see that I don't think this is the only one that they made in FIDIC 2017. Now, almost 10 years on, there does not seem to be any central position as to this duty and what this concept means. There's no clear remedy for its breach and no consensus, from my understanding, of whether it differs meaningfully from the retained obligation to make a fair determination. The non-deeming agency point is obviously more direct than the neutrally wording, but the way in which it's been drafted is very much in terms of status of the engineer, when actually what it's trying to get at, it seems, is a standard of conduct. And that in itself, and certainly from the debates that I've seen and participated in, it has actually caused a lot of academic discussion and a degree of confusion, because it remains that the engineer is still appointed and are paid for by the employer. And also, employers have responded predictably by deleting these provisions. But ultimately, I suppose the question has to be, does this actually matter, or is this something for an academic debate of FIDIC scholars? My view is that it does, but not necessarily due to the specific language that is being used, because experience has shown that the concept of a neutral or impartial engineer is something that remains misunderstood, or at least widely misunderstood and not fully appreciated. And perhaps it's better to say and accept that it's difficult to describe. And because of this, and because of the central role that the engineer plays when making determinations to which this duty of neutrality or acting neutrally applies, this can cause a lot of angst on projects. But the honest position, I suppose, from a practical perspective, is many contractors still believe the engineer favours the employer. Many employers still believe that truly neutral engineers favour contractors, and the drafting doesn't in itself fix this problem. Now, why is this important? And then, as I said, it's because the engineer plays this central role, and the engineer's role is critical to the proper functioning of the contract. Parties' relationships can break down where different expectations of how the engineer is going to exercise its duties arise, and also the consequence on the claims procedure. And this, in terms of the engineer, another aspect that has come up is again in relation to its enhanced role. Well, in 2017, FIDIC built on the developments in the Gold Book in relation to claims and disputes. They introduced claims and dispute as defined terms, and introduced three categories of claims, which are essentially employers' claims for additional payment, reduction in the contract price, or extension to the defects notification period, a contractor's claim for time and money, and a third category is essentially everything else. Now, so far so good, it seems. The difficulty was in relation to the third category of claim, because it's likely to relate to things that the engineer has already done or should have done but not done. And it also included determinations made by the engineer, at least textually. And so I suggested back in 2018 that the intention behind this third category of claim is not clear, and appeared to be a backward step, another backward step to the position under the 1987 edition of the Red Book, in which the engineer acted as a pre-arbitral decision maker, and was a point that was specifically addressed in the 1999 editions with the introduction of the Dispute Adjudication Board. Now, I'm not saying that this is anything to do with me, but it does appear to be a point that FIDIC conceded. And in the 2022 reprints, various amendments were made. They're not the easiest to follow, I have to say, even when in line. But definitions of claims and disputes were amended and clarified. Certain matters on which the engineer was required to make a determination under 3.7 were expressly included from claims, and determinations were deleted from the third category of claim. And this, I think, has to be positive. Now, the final topic that I wanted to talk about a bit about the engineer again goes back to another prediction that I made. To create greater certainty, FIDIC introduced significantly enhanced contract management procedures. And many of those procedures require the engineer to do something by a certain period of time. And for example, a missed deadline could produce a deemed consent or a deemed no objection, binding the employer. And in that situation, I wondered whether or not this is going to expose engineers to potentially greater liability. Now, I don't believe that this is something that's been discussed particularly much since then. But either way, it's something for engineers in the audience to consider in terms of their consultancy appointments and PI policies. So that's the engineer. Now the part of the 2017 forms that has generated most discussions, and more than any other provision, the claims provisions. Now, when I started to think about what I was going to cover in this webinar, my initial intention was to try and avoid talking about the claims procedures. The reason was mainly because, despite the amount of additional pages that were taken up in the procedures, it largely comes down to an exercise of reading them and working your way through all of that text. However, on reflection, I recognise that this is a topic that both many people in the audience will be expecting me to cover on this webinar. And it's also something that, when considered from a risk allocation perspective, goes back to several of my other predictions that I made when the contracts were launched. Now, the first topic I'm going to cover is the 322 days. Now, as I said, FIDIC's aim for the enhanced contract management provisions was increased clarity and certainty to reduce risks of disagreement regarding the application of the contract terms. This included more prescriptive step-by-step procedures, what is expected of a particular party, when it is expected to be done, and what the consequences are if they don't comply. Now, this includes stricter requirements in relation to communications, an increased number of time limits, time bars, deeming provisions, and notices of dissatisfaction. And this is most acutely seen in the claims provisions in clause 20 and the dispute resolution provisions in clause 21. And this is where my figure of 322 days come in. Because once a claim has been submitted, the parties have no option, I think, but to see it through to its resolution or risk losing its rights. A process that can take 322 days with the potential further 56 days before the dispute can be referred to arbitration. Now, I can walk you through this, but I think hopefully it's relatively clear from the slide that I have presented. Now, going through this process, none of this is optional. Once you have started and once a party has started, you're on a conveyor belt. I describe that as the claim train. And miss a step, you would potentially lose your entitlement. Now, as I said, I think the reason behind this was to provide certainty and also, in a slightly different way, to encourage dispute avoidance. Back in 2018, I wondered whether, because of this process and because of this conveyor belt, whether this was going to, in fact, prolong the resolution of disputes. Now, almost 10 years on reflection, I'm not quite sure that that was right, and I'm happy to admit that. I think the jury is still out. But what has become evident is that it has caused claims to be stacked up with multiple claims running in parallel on a staggered basis, increasing workloads for the project participants. And this means that, and this applies both to claims, however big and however small, they all follow the same process. And because a party can't pause it, it cannot park a claim while everyone gets on the project, it cannot choose its battles. And the product has been not only certainty, but also inflexibility. Now, the answer to this, I suspect, at least from what FIDIC will say, is the first one is that the procedure expressly involves stages for agreements between the parties. There's consultation and opportunities for agreement. And the second is that the standing dispute board, which I'll come on to later, can facilitate the process and encourage flexibility. Now, That's all very well and good, but it's my experience and also the experience of others who are there on the coalface working on these projects and under 2017 contracts, particularly where public authorities are involved, that some parties need decisions, and so the process must be followed. It's also human nature when following a process to treat everything equally and not necessarily to take a stand back. Now, the second topic I wanted to talk about in terms of claims was the issues of certainty, equity, and reciprocity. So we've talked about the certainty that has been provided with more prescriptive procedures. And two such examples relate to the requirements to give a notice of claim and also a fully detailed claim. Now, the notice of claim is to give in 28 days from a date from awareness, and the fully detailed claim are 84 days to awareness. Now, however, in FIDIC 2017 and subclause 20.2.5, a provision has been provided to let the engineer decide when considering a claim whether a notice is late, whether a late notice or a late claim is justified, taking account various things such as whether and to what extent the other party would be prejudiced by the acceptance of the late date and the other party's prior knowledge. Now, this in itself, again, seems another return back to the 1987 drafting and talking about prejudice. Now, in principle, that power or opportunity for the engineer to excuse a late notice could be described as a humane answer to the criticism that a failure to comply with all formalities for these can kill meritorious claims on a technicality. And it does this by bringing in an element of equity. I wondered, again, going back to my commentary soon after the publication of the editions, that whether or not this waiver provision was likely to be sort of much argument, because it has the effect of removing that certainty that FIDIC had sought to introduce. Now, theoretically, I think this is probably right, and certainly there's a lot of academic discussion on it, but in practice, it seems a bit less so. It remains, from my experience, lightly tested in anything published, but there is this deeper tension of, on the one hand, providing a stricter regime, and then on the other hand, giving the engineer a discretion to disapply it in circumstances. You cannot have both certainty and equity. Now, the final point to mention about claims is reciprocity. Now, as I said, one clause 20, governs both parties' claims, replacing the asymmetry in FIDIC 1999. This is a real improvement, and I do think that contractors benefited and appreciate it. Now, finally, before I move on to dispute boards, a lot of the debate has moved on, certainly from the debate that we previously used to have in terms of the 1999 suites and clause 20. And so now what we're seeing is more discussions and more arguments over whether or not a failure to comply with time bars and condition precedents goes to jurisdiction or admissibility with regard to the tribunal. There's still the civil law arguments that come out in relation to time bars. And I've also seen greater deployment again from the prevention principle in common law jurisdictions, which everyone thought had been put to bed a few years ago. Now, everything I've just described, if not accepted, is supposed to end at a standing dispute board of experienced people who already knew the project. So let's talk about dispute boards. So the Dispute Adjudication Board was introduced in the 1999 suites. Its origins can actually be traced slightly further back, but was included in all three of the 1999 forms of contract, the red, yellow, and silver book. Now, the purpose of the DAB was to replace the engineer's role as pre-arbitral decision maker, because there's an obvious conflict there. And in the red book, you had a standing board, but in the yellow and the silver book, you had ad hoc boards. Now, in 2017, FIDIC chose to incorporate standing boards in all three of the books. It also expressly set out a dispute avoidance clause emphasising the board's dispute avoidance role. So this was again codifying that role. It included detailed provisions regarding the appointment of the dispute board, where a party won't engage, because this was found to be in practice one of the issues that happened with the 1999 forms. And there's also enhanced provisions regarding the enforcement of dispute board decisions, binding but not final decisions, dealing with the issue that came up in the Passera litigation, and also was the subject of a lot of debate. Now, at the time, again, going back to 2017 and 2018, I suggested, and this was that the introduction of a standing dispute board across all three contracts was probably the most far-reaching of all of the changes that were made in relation to the dispute board. Now, I think, based on the feedback that I've got, that this judgment still holds. And it's also the single area where I've experienced most public debate on the FIDIC 2017 contracts, and FIDIC has been most visible in working on in relation to those contracts. Now, before I go into why and what the issues have been in practice, in the spirit of full disclosure, I would like to say and make it clear that I am a supporter generally of the concept of standing dispute boards. I think in the right place with the right people, they are a very good thing. And this is primarily not because of the dispute adjudication role that they have, but the avoidance role. They can facilitate flexibility. The second thing about standing boards, which again sometimes gets misunderstood, is the point about a standing board is not so that you ought already have a board in place in order to adjudicate disputes as and when they arise. But the standing board is appointed from an early stage in the project and is kept updated by the party project participants and have regular meetings to understand process in order to help the parties to identify pinch points, issues that are arising at a very early stage, and then to seek solutions before they become certainly disputes, and in some cases, claims in itself. Now, standing boards and standing dispute boards are a difficult concept. And it's a bit like the idea of the impartial or neutral engineer. And it's a difficult concept that people have really struggled to grasp and to fully understand, because, and I'm already starting to do it now, and there's a bit of hand waving going on, because again, it goes down to behavior and open communication rather than necessarily following a particular process. But they can be incredibly effective. Now, the problems that I identified at the time is that for this to happen, firstly, they need to be appointed. And secondly, for a standing board now to be appointed on every FIDIC 2017 contract, not just the red ones, this requires a supply of experienced members that the market had not produced up to that point in the necessary scale and price point. So there's a definite need for these things. And again, we talked to a lot of people about their experiences, both in relation to, particularly in relation to 1999 and the dispute board provisions. Much of the feedback is that once they've had one bad experience on a dispute board, for whatever reason, that's almost sort of fundamentally changed their view forever as to whether or not they will do it. So now looking to how that's been received and in practice. Now, the first thing is, and it won't surprise anybody, that a very common amendment that we see is from the standing board requirement to be replaced with an ad hoc board, and perhaps probably even if that hasn't happened and there's still a standing board written into the contract, the parties still don't appoint them for whatever reason. As I said, a lot of this comes down to a lack of understanding or appreciation of standing boards, but it's also that given the approach and the nature of the changes that FIDIC introduced into 2017 with all of the procedures, the standing boards are very much looked as part of a process for the resolution of disputes rather than to appreciate the benefits of why we have standing boards in the first place. Now, FIDIC's response came out in 3 ways, and the 3 practice notes have been issued over the last sort of just over 2 and a bit years, and much of the audience may not know about them. And this is through a forum that Dispute FIDIC has established. And these practice notes talk about the dispute avoidance role of dispute boards, the appointment of dispute boards, and then dispute boards decisions. Now, you can see that the first 2 of those go to things that have been arising in practice since the 2017 editions have been being used. There was also, and it's not mentioned on this slide, but in the reprint of the 2022, the 2022 reprints, the DAB member impartiality period was reduced from 10 years to 5 years, which seemed to be a practical response to the shortage of eligible and experienced members. Now, a quick 90 seconds on Passero and enforcement. Now, under the 1999 forms, a party facing non-compliance with a binding but non-final DAB decision had no clear route to enforce it. And this was exposed in the Passero litigation in Singapore. Now, FIDIC issued a guidance memorandum in April 2013 to address this, but that was only a guidance memorandum and would only apply once it was incorporated into the contract. The 2017 drafting now carries that fix into the standard text in 21.7. And this is useful because it shows that actually proper feedback can influence the drafting of these contracts. Now, I think probably many people were aware about that, and there's not much more to talk about. But there are 2 things that it's worth mentioning. And firstly, that UNCITRAL recently published some model adjudication rules, which include provisions for the enforcement of these decisions through expedited arbitration rules. And also with the newly published ICC rules, there's now a highly expedited arbitration procedure, which people might want to consider in terms of the enforcement of those decisions. Now, moving a little bit, moving further on now, I'm going to actually go back to have a look at some of the substantive provisions where the day-to-day focus actually is. Now, each of these are where FIDIC made some amendments in the 2017 editions when compared to the 99 editions. Now, the first one we can talk about is the program. The 2017 editions came much more detailed requirements as to the contents of programs. And this actually follows the Red Book subcontract approach. In principle, this is a very good idea and makes sense. And I've seen it being used and adopted and complied with in some very large projects. The difficulty is that by increasing the requirements, the content requirements of a program for that program to be compliant, presents challenges for a contractor and also gives a reason why the engineer may not accept a program. Again, not necessarily on a technicality, but for reasons that aren't that important for the overall progress of the projects. And it's hard enough, as people will know, for there to be established and accepted programs, particularly as the projects are developing, to take into account for example, the delays and events that are going, even when the liability for those delays are being considered. And so what happens is it can create difficulties in terms of establishing updated baselines for the purposes of assessment of progress and ultimately extensions of time. The second topic I want to talk about is concurrent delay. And in the 2017 editions, FIDIC, following industry practice, sought to expressly address the allocation and treatment of concurrent delay in the time provisions. But the way in which it did this is it didn't actually resolve to which party has the benefit of concurrent delay. It left it for the special provisions included in the particular conditions. Now, this is again something that I flagged up, and what we're seeing is that, understandably, where drafting is being and the drafting of the particular conditions are being led by employers, they're seeking to extinguish rights to extension of time where there is any culpable delay that is concurrent, and also extending this to include clauses deeming program float to belong to the employer. The contractor side, on the contractor side, where there is any leverage on this, the trend has been to look to the SCL protocol, which is largely about taking time but not cost, but with a float expressly belonging to the project or to the contractor. Now, this is a hard question, I think, that is being left to the particular conditions, and it's very much a decision as to a question as to bargaining power rather than what is a fair and balanced approach. Now, the third topic is exceptional events in COVID. Well, many people will know that exceptional events is the new name for force majeure, as was in the 1999 editions. And clause 18, which deals with this in the 2017 editions, got a real world stress test that, understandably, nobody, when they were drafting those conditions, those clauses, anticipated. Many of those claims failed. And one of the reasons why these exceptional events claims failed was not because the clause required the event to prevent performance and not make it harder or more expensive. And this is one of those, and again, this is not specific to FIDIC, but this is one of those areas where it's very important to actually read the contract very carefully. The market's response is obviously to draft pandemic-specific and change in law drafting, as well as to try and bring in cost escalation provisions. And I'm seeing that in particular conditions on both sides of the table. The next topic is the fitness for purpose indemnity. Now, this is one of those very controversial points that came out, which actually goes down to substantive risk allocation. I said it was going to be controversial. It's unlikely to be resisted by contractors, and it has been shown to be. It's one of the most consistently amended provisions, I think, in the suite, at least to the extent that the contractors had an opportunity to do it. And the insurance gap between an express fitness for purpose obligation, indemnity, and standard PI cover is now well documented. Just when we're talking about fitness for purpose, it's also worth noting that FIDIC in 2017 tried to address an issue in terms of the general fitness for purpose obligations, because previously it was drafted and dependent on what the contract said, and the question then gave rise to a sort of an empty Hogarth issue as to what happened if the contract is not clear. So it then included a fallback provision to the works need to be fit for their ordinary purposes. Now, that in itself is, again, a difficult concept to apply, particularly where you're trying to bring in certainty. Now, to canter through a few other flashpoints, unforeseeable physical conditions, clause 4.12, and if anybody knows me, they know that I like talking about that clause. This remains an area that's either subject to a lot of debate and amendment, but it's also one of those areas that still gives rise to very significant claims. The limitation of liability changes have been well received. In FIDIC 2017, they restructured and clarified them and moved that clause earlier on. These are still, however, as is standard in big international construction contracts, some of the provisions that are most negotiated, typically in terms of caps and carve-outs. Then we have variations. I said that I think that many of the changes that were made to the variations provisions are welcome, have been welcomed. They are good. They provide clarity. For example, they require variation instructions to be identified as variation instructions, and also the 2017 editions filled in a gap as to the valuation of variations in the Yellow Book and Silver Book. This is all a good thing. But there were two other points that I raised, again, back in 2017-18. The first one was what happens where there is still a debate as to whether or not an instruction that has been labeled as a variation instruction is actually a variation, as in whether conceptually it's a variation and doesn't fall within one of the grounds. That's still unresolved. And the second one I said is I questioned whether or not unforeseeable as a ground for objecting to a variation provided any greater certainty. I think actually I've been proven wrong on that point. Now, the last 3 points I can canter through very quickly. The first one is that there was termination, when there's termination convenience, 2017 introduced a contractor's right to loss of profit. I predicted that employers weren't going to be particularly accepting of this, and that has proved right. In terms of termination for cause, a material breach was introduced, and I questioned whether or not this provided certainty because of the fact that material breach is not an established, or at least term of art under common law. This has now changed, I think. Material breach is both now a concept familiar to civil lawyers, and there is now quite a long line or developing line of English authority on that. And then finally, taking over, I flagged the fact that there were some new preconditions in terms of the taking over, and this is very much dependent on the engineer staff being available to get everything over the line. Again, I think the jury is still out on that. Now, everything I've said so far is about what FIDIC wrote in the 2017 contracts. But almost none of you, if you're working with 2017 contracts, are doing it in an unamended form. And indeed, the contracts require there to be particular conditions. So let's move on to what the market has been doing with these forms. And the starting point for this is the amendments to the 1999 suite. Now, this is a list of amendments on the screen of amendments that were commonly made to the FIDIC 1999 forms. And this is a list that I drew up in, I think it was in 2013, when I was giving another talk. Now, these are what I would describe as FIDIC amendments rather than other types of amendments, which are, for example, project specific, and the most obvious one is where you're working offshore, or governing law specific amendments. Now, if we go on and compare that in the next slide to the 2017 common amendments, you will see, and if you don't mind, I'll flick between the two, you'll see that not a lot has actually changed. So actually, what we're seeing is that there are almost greater cause to amend, or greater tendency to amend within relation to the engineer's determinations that I've talked about, and in relation to concurrency and float, which I talked about. Variation pricing has become less of an issue, and the enforcement of DAB decisions has been addressed in 21.7. Now, thinking about that, that's the standard ones. Now let's actually look at why and where we're going on this one in the context of 2017. In many ways, and I think this is almost trite to say this, but the amendments that we see in these contracts very much depends on who has the leverage in any negotiation and who holds the pen. And this can work both ways. And certainly when we're looking at the procurement environment, what we're seeing is that there is there's less amendments being introduced where you've got World Bank and MDB funded projects, And then there's a scale, and the scale builds up through private finance, experienced private developers, and government public employers. The one caveat I said is in relation to private finance, lenders will have their own amendments which will come in whatever. And so obviously you'll see those. But in terms of the FIDIC amendments, certainly the anecdotal evidence is that generally they're quite happy to leave the contracts as they are. Partly because of the risk of interfering with the contractor's cash flow. The exception, obviously, is going to be in relation to the Silver Book. And if you think about those specific amendments in practice, again, what we're seeing, and I've mentioned many of these, is that the that the amendments, and again, it cuts both ways, trying to address this question of the acting neutrality and the requirement for engineers' consent, trying to address the concurrency and float in particular conditions. It can go both ways, shortening or lengthening the time periods, removing and enhancing or deleting the reciprocity in the claims provisions, deleting the standing dispute boards and replacing with an ad hoc or dispute boards entirely. And finally, and this is one that I noticed and came up with a while ago, is about severing the connection between the claims and the DAA procedures. And we go back to that 322 days. The difficulty or the challenge, and certainly if you talk to dispute board members who are working with 2017, is what they're seeing is because you've got this train, there's a continuous flow of claims that are going on through the disputes procedures, because the parties have no option otherwise but to do it, or certainly many in certain circumstances have no option but to carry on. And that gives little time. There's no fire break. There's no opportunity for a breather, and you can sever that connection in the time period relatively easily. And that can be quite effective to recalibrate the relationships with the parties. Now, in terms of the adoption of these forms, no, I wouldn't be sitting here now talking about them if they weren't being used. Now, I noticed again back in 2017 that it took almost 10 years in some jurisdictions for the parties to move from the old FIDIC forms to the first editions in 1999. And then this webinar now sits on almost the 10-year mark off the 2017 editions. And what we've seen is that actually the uptake has been driven in terms of quantity, firstly through the MDBs and the relationship that FIDIC established with the MDBs, including the World Bank, to use those forms. Now that drove the adoption in donor-funded work. Private employers have been slower, and the 1999 forms remain in circulation, largely based on familiarity, existing precedent banks and negotiated amendment packages that all are present. But what we're also seeing, even with the 1999 receipt, you're seeing the 2017 changes, or some of the changes are being incorporated in it. And inevitably, there are regional variations. Now, finally, it's also worth talking about the FIDIC Golden Principles. Back in 2019, FIDIC published what they considered to be the 5 golden principles for a FIDIC contract to be a FIDIC contract. Even though they were published standalone in 2019, they're actually included within the 2017 guidance. And there were 5 of them, as I said. The first one is that the duties and responsibilities of the contract participants must generally be as implied as set out in the conditions. So you shouldn't be changing the duties. They need to be clearly drafted. You don't want to change the risk-reward allocation. All the time periods in the contract must be of a reasonable duration, and all formal disputes must be referred to DAB for a provisionally defining decision. Now, if you look back at what we're seeing in terms of the FIDIC 2017 specific amendments in practice, you can see that many of those, if not all of those, in some way or other, contravene the FIDIC Golden Principles. And that's not to say that the principles are binding. They are, to some extent, aspirational and have no contractual effect. But actually, it gives you a good insight as to the way in which the market has approached what FIDIC has tried to achieve. So now let me try and add all of this up. I'll go through and mark some of my predictions. So I said that there would be an increased administrative burden in the parties, and I think I was right. I said I don't think they were suitable for all potential users. Again, I think it's right. These are very sophisticated contracts. They're long. They required a lot of resource and a lot of discipline. However, they can be used and have been used successfully. I suggested that neutrally, and the use of the word neutrally may not resolve the engineer conundrum in terms of its decision-making role. I think the jury is still out. And I think this is a more fundamental issue about the export of a very English common law concept worldwide. I suggested that the engineer potentially exposed to greater liability. Haven't seen much discussion on this, and so that's quite interesting. I mentioned that the third category of claims was unclear. I was right on that, and FIDIC has amended that in the reprint. I said that the claims process and time bars would be subject to much debate. Inevitably, they have been, and arguably that may have been one of the understatements of the last 10 years. I mentioned that the claims in DAA procedures may prolong resolution of disputes. I'm not sure that that's right. I think that, again, the jury is still out because I think there's something more fundamental and it's about behaviours. I said that the waiver of notice time periods, time bars would be a source of disputes. Again, that's unclear. The fitness for purpose indemnity was likely to be resisted by the contractors. 100%, absolutely, very much so. The ordinary purposes, fitness for purpose fallback is likely to be amended. That's what we're seeing. The unforeseeable ground to object to variations is uncertain. I think I'm probably wrong on that one, actually. And again, there's a debate over it, but I think I was probably wrong. The material breach being less certain in common law jurisdictions. Again, I think I'm wrong, but that's largely because the case law has developed over time. Loss of profit for termination for convenience likely to be resisted by employers, very much so. That standing DAABs represent a significant change. Again, I think I was right on this, and I think that it's been the difficulty of applying this in practice. I think the intention is a good one. The adoption and implementation is more difficult. I also said that it's difficult to amend, and this is, and again, I'm willing to make in the spirit of full disclosure, I like the 1999 editions, and that's not just because I've spent years studying it and using it. I think they work very well, and they work as a good baseline in which to amend up. Now, my view of the FIDIC 2017 editions is what they've done is they've now produced a very sophisticated contract that probably needed to be amended down. And because there are so many interrelated provisions and overlapping procedures, it would make it difficult to amend. I think the reality is that the things that I thought were going to be amended have just been accepted because that's a central feature to what the 2017 editions are. And actually, much of the amendments that we're seeing, as I said from the previous slides, are what we've seen before with the 1999, and so therefore can be relatively easy to amend. I said the uptake will be slow. That's right, and that's not just because looking back on the 1999 edition, the uptake of that was slow. I do think that the differences between the 2017 have caused a lot of people to pause. I also said at the time that it'll be interesting to monitor, when talking about the uptake, to monitor the uptake and whether or not the international construction industry can cope with the increased administrative demands, and whether there is in fact an appetite for a FIDIC form light, such as a minimally amended version of the 1999 suite. And I will come to that at the moment, because that's partly been answered by the Green Book, second edition. There are some things that I didn't foresee. I didn't foresee COVID, and I don't think anybody did. Well, obviously. I didn't foresee that FIDIC were going to publish the 2022 reprint, and I didn't foresee the funder appetite for using the 2017 forms. So now, where next? As I said, it'll be interesting to monitor. In 2021, FIDIC produced the second editions of the Green Book, and the Green Book is their short form contract. Lots of things happened when that came out, and it increased what it considers to be the appropriate threshold or appropriate project value up to $10 million for the use of this form. Now, this form is short, certainly compared to the 2017 editions. And I can't quite remember the numbers, but I think originally it was about 10 or 11 pages, and now it's about 20 or 20 in the 20s. So it's much shorter than the others. But also it's more sophisticated than the first edition of the Green Book, and has now adopted the engineer. We've had the reprint in 2017, and then since then, probably one of them, what I think is probably the most significant thing, is that FIDIC has published the Carbon Management Guide. It's the newest development, and many people may not have seen it. And this is all about trying to deal with the issues that we have about management of embodied carbon and carbon emissions in construction projects. But finally, where we've got to is the launch of Objective 2030. And this is the FIDIC Contract Committee is now scoping changes to the red, yellow and silver books under those objectives, and looking to produce fresh additions or possibly a further update. This question is still open. And so the question, and very much what FIDIC Contracts Committee is looking now at, is feedback as to whether or what we're looking for is a further revision of the 2017 or a step back. So in conclusion, now I ended the blog, as I mentioned earlier, in December 2017, with 3 words: only time will tell. Well, to some extent, time has told, and here is what I think it said. FIDIC has made improvements to the substantive provisions that have generally been accepted as a good thing. Indeed, even where the 1999 forms are used, it's now quite common to see that drafting from 2017 being incorporated. Overall, FIDIC produced a much more certain contract, but also a less flexible environment. The certainty is real, and I don't want to be churlish about it, because on a well-run project and properly resourced parties, these forms do what they were designed and intended to do. And as a result, well-resourced contractors on large projects, I think, can cope. The burden may, however, fall hardest on mid-market work, unsophisticated employers, and in jurisdictions that don't have the experience of managing these complex contracts. But that then becomes more about an argument about which form to choose, and not about the form in itself. Certainty has real value, and particularly, it seems, for lenders and public employers who need auditable decision trails. But the price has been paid in obtaining that certainty, and that price is in flexibility. And flexibility, from a practical perspective, does a lot of the heavy lifting in maintaining relationships and progress in projects. The ability to let something go, to choose your battle, to deal with a project commercially rather than procedurally, that's not necessarily bad behavior, and that's how a lot of projects get built. Experience has shown that parties often do not comply even with the simpler procedures and requirements of the first editions, the 1999 editions, and indeed didn't even comply with the 1987 version of the Red Book, which led to some of the time barring provisions that came into the 1999 things. A degree of flexibility can help the parties to focus on the real issues and to choose their battles. So on my central question, yes, I think the risk has moved towards the contractor, but that's not necessarily down to the drafting per se. What has actually happened is that 2017 forms have created a procedural regime whose burden falls unevenly on the contractor and left everything else far more exposed to behaviour. What this has done is it's created a different creature from the 1999 editions, and one that requires the project petitions to function and to perform properly and as intended. Feedback has shown that the 2017 forms are susceptible to being amended quite easily to remove many of the provisions that are in the contractor's favour. But if there is somebody outside of that who can impose a degree of discipline, such as the funders and development banks, particularly where the onus is on keep ensuring that the project doesn't fail and the contractor stays solvent, the balance can hold up. And so I suppose, if the question is, did FIDIC 2017 shift the risk to the contractor? The answer is probably no. Well, at least not directly. It's the party's behaviour and FIDIC that does this, and the contracts actually give it more places for it to influence that shift. Now, as a final comment, at the FIDIC Users Conference, International Users Conference in Sabre, it was noticeable that the focus of the discussion was much more now about party behaviour than it was about the contracts. Contracts don't, I think there was a saying along the lines of, contracts don't make successful projects, people do. And that, I think, is an encouraging reflection, particularly by FIDIC and the FIDIC fraternity, that for a lot of this, it's not about having academic debates as to what particular words mean. And we need to look beyond that in terms of the party participants and ensuring that they fully understand what they're signing up to, and that they have the capabilities and capacities to deliver their project. So I'm going to stop that now, which is, as I hoped, in about an hour and 10 minutes, to leave a few minutes to questions and answers if anybody has them. Now, from a practical perspective, I think the way to do this is through the question and answer, as opposed to in the question and answer function, as opposed to the chat function. And I'm also going to ask you, if possible, not to ask me about specific clauses. And that's not because I don't want to talk about specific clauses, but because otherwise I'm going to have to again start getting the contracts out, and it might not be a bit of interest to anybody else. If people don't want to stay to the question and answer session, that's absolutely fine. And I do hope you enjoyed this webinar. We have had a question as to whether they get a copy of the slides. Absolutely, I will distribute the slides to all participants once this is finished. This has also been recorded, and so if people want to go back or want other colleagues to watch it, certainly you're very welcome to. We'll get the recording as ready as we can, as soon as we can, and then it will be the link will be distributed. Okay, I'm going to give you 2 more minutes in case anybody's other questions, because none seems to be coming in. But otherwise, I'd like to thank you for attending, and I hope you have an enjoyable day. Oh, we have some questions. So with the growing adoption of NEC forms, how does the FIDIC reform stack up in your opinion? Interesting question. Because around the same time that FIDIC produced 2017, the NEC were producing NEC 4, I think it was at the time, which was very much targeted. One of the principles that NEC adopted when they were doing that was to target and make changes that would make it more attractive and more adoptable by the international market. So they were trying to, so I'm not necessarily saying as a direct competitor, to provide a viable alternative. And the NEC adopted a very, very different approach to FIDIC, both in terms of the 2017 and the way in which it's drafted. The NEC forms is very much a build up, where you have lots of options and you can choose and make them more sophisticated. Whereas I said, to some extent, the 2017 is a build down concept. The challenge that NEC have got, there's probably 2 central challenges that NEC have got internationally. It's a very, very different form from what people are used to seeing in terms of engineering contracts. this is intentionally so when it was first drafted, but it doesn't read like what people would normally expect to see. And so the NEC have had to undertake a large education program to get people in. But also, these NEC forms are a lot shorter than FIDIC contracts. And so it leaves an awful lot left to the parties and the way in which they behave, which is not codified in the contract. Again, the direct opposite of that. NEC forms are used very successfully internationally, particularly in common law jurisdictions, Hong Kong, Australia, South Africa. They have been starting to use in the Middle East, but a lot of that's down to the fact that the project teams are the same project teams who are working around the world rather than specifically the form of the contract. The other point to make is the fact that now what we're seeing is that both FIDIC and NEC will look to each other as to what amendments they're incorporating and then making decisions as to whether to bring them in. Some of the changes that we've seen in NEC, for example, in relation to early warning is a good example, has now been adopted in NEC. So, in the absence of any further questions, I'd like to. Oh, we've got another one. Sorry. The newest version of the question is, in the next version of the main FIDIC forms for projects in developing countries that are not necessarily used to FIDIC forms in general, would further revisions of the 2017 versions be more helpful or scaling back from them? My personal view, and that's all I can give, I take no responsibility for it, but my personal view is I would go back to the 99 editions. And I think in some ways, the 2000, and certainly from working in projects in developing countries, even on the 1999 editions, there have been struggles to follow all of those procedures. And so actually by providing what FIDIC describe as greater certainty is actually creating probably more problems. I think a lot of it comes down to, as I say, I don't want to say colonial, but education and understanding as what is being intended and not necessarily through more drafting and more words. So the next question is, do I think that the new collaborative contract is filling a demand or is more to compete with NEC? So this is in relation to the fact that the FIDIC Contract Committee, in addition to Object 2030, is working on a collaborative contract. And in all honesty, I don't know. Without wanting to be risk of being overly controversial, collaborative contracts have been around for years, and I think that they can be a good thing in the right place. But a lot of what we're talking about in terms of collaborative contract is about behaviours, but where people need certainty, it becomes harder to codify and to legislate for this within these contracts. I think that it's good that FIDIC should be involved in a debate as to the collaborative forms. But I think that because it's still something that is something that is not widely adopted as a concept, it's going to take time for there to be an uptake and for it to be developed. NEC, obviously, to some extent, at least some people might describe it as a collaborative contract. My personal, again, probably to answer the question, my personal view, though I haven't actually spoken to anybody about it, is I don't think that FIDIC are trying to compete with NEC. I think that they're very much doing their own thing in a sense of what they think the market will need. But given the time it takes for any of these contracts to be used, it's a difficult one to say, and I think it very much depends on the contracting landscape at any given time. One of the things, going back to something that I did mention about COVID and the exceptional events, is that this is something that nobody actually envisaged at the time for obvious reasons. But there's a bigger question that I have, is the fact that given the current geopolitical situation, as well as things like COVID and the changes to the climate change issues, whether or not the standard of the accepted and traditional approach in terms of risk allocation and drafting that is used in a lot of these contracts is something that we now need to go back and reconsider again, and look at afresh, as opposed to just amending to work out whether or not that's it. Whether that's part of a collaborative contract or whether that's just part of a wider industry project, I'm not sure. So on that note, I am going to finish. But again, once again, thank you very much for joining me. I do hope you found it helpful. We will distribute the slides and the video once ready. Many thanks. Bye.